books about the law of self-defense. He's got blogs, he's got classes. If you want to know anything about the law of self-defense, he is the man to speak to, and we have him with us today. Good afternoon, Andrew.
Glad to be here. Thanks for having me.
It's wonderful to have you. I want to talk to you about, we've told the audience a little bit about this Florida versus Billy Woodward case and the fact that the defense had put on a stand your ground immunity defense, which was not successful. What do you think are the chances of a self-defense claim being made here and being successful here?
I think they'll certainly make it. I think it would be very imprudent of the attorneys not to, but the chances of it being successful, I would say, approximate zero.
Why?
Well, it's so profoundly defective on so many grounds. Any claim of self-defense, and this is true of all 50 states, has a very specific set of elements that must be met that are subject to attack by the prosecution. There's at a maximum of 5 of those, and unfortunately for Mr. Woodward, he's extremely vulnerable on every single one of those.
And what are they?
They are innocence, imminence, proportionality, avoidance, and reasonableness.
Yes, let's talk about those. Innocence is the first one. If you are consulting with Woodward's attorneys, how do you try to establish that first prong of the self-defense claim?
Well, innocence is the first of those 5 elements, and it essentially means you can't be the aggressor or the provoker in the conflict. You can't be the cause of the use of force. And unfortunately for Mr. Woodward, anytime you go to the fight instead of the fight coming to you, it simply does not look like self-defense. Right. And in this case, the victims of Mr. Woodward's force were in their yard, feet from their home. He went to them. That does not look like an act of self-defense. That looks like the act of the physical aggressor, which would fail him on the element of innocence. And if you lose innocence, you lose self-defense.
Yeah, it's a major problem for him, the fact that he's crawling. And you know, I know watched the hearing for the immunity claim. They showed a lot of video, and I anticipate we'll see a lot of video in the trial of this case. And he's crawling in camouflage onto their lawn. That sort of, it ruins, I think, maybe all 5 of your prongs.
Well, it contributes to vulnerability in all of them, and certainly the manner in which he approached them. I mean, it would be theoretically possible to imagine him approaching them in a manner that wouldn't suggest aggression, like he just wanted to simply speak to them, and he would just walk across the street to do that. But there's no innocent explanation for sneaking through the woods across yet another neighbor's property to approach them from the flank.
Yeah, and one of the things that the judge pointed out in the order denying the stand your ground immunity is that in the past, it appears that Woodward's wife has sort of talked him down when he's had similar, inclinations to go after his neighbors. And it seems as though Woodward specifically waited for his wife to go to bed to do this. Do you think that that type of thing is also going to be one of the many nails in the coffin of this self-defense claim?
Frankly, I don't think so, not because it's not necessarily relevant. I think it was totally legitimate for the judge to bring it up, but there's just so much more damaging evidence against him than that kind of speculative concern about what the wife might or might not have done if she hadn't been asleep.
Now, let's talk a little bit, and I know the reason I knew of you, Andrew, is because when I used to cover the George Zimmerman case for, when it was on so much TV, Legal Analyst, you were really tweeting up a storm with really insightful thoughts on that. And one of the things that I thought was interesting, and Vanu, I want to talk to you too about this, is that Mark O'Mara, the attorney for George Zimmerman, decided not to pursue an immunity defense of stand your ground, not to have the hearing that Woodward's attorneys has had, and instead to put forth the self-defense claim at trial. One of the things that does, Andrew, and correct me if I'm wrong, is to sort of negate the need to have the defendant testify himself, because the defendant has to testify at a stand your ground hearing. Isn't that right?
Well, not necessarily, but I think it would be very difficult to get a judge to grant immunity if the defendant's not prepared to explain why it was necessary for him to kill the person. Right.
So instead of doing that, Mark O'Mara seemed to have taken the risk of not going for the stand your ground hearing and rather letting a jury decide. And doing that, he didn't have to call George Zimmerman. Do you think that Woodward's attorneys now wishes that rather than going for the immunity, they had just decided to defend this case straight out?
I think in the Zimmerman case, it was the right move not to go for immunity, just given the politics of the situation. I mean, frankly, it was a perfect case for an immunity hearing, Zimmerman, absent the politics. because there was literally zero evidence in that case that was inconsistent with self-defense. I mean, the case for the prosecution was a train wreck from the first day to the last day. But the politics around the case were such that I think it would have been unreasonable to expect any trial judge to simply grant Zimmerman immunity and not put the case in front of a jury. In this case, it's different. It's really the opposite. In this case, there's almost no evidence consistent with self-defense. So I'm not sure what the defense had to lose by going for the immunity hearing. Clearly, they didn't get close to getting immunity. I mean, Judge Earp didn't just say they didn't meet the immunity standard. He says they were vastly short of that standard. So you take the shot, you see what you can get, and obviously they didn't get it, and now they're going to have to make the same arguments at trial.
Now, Vinu, would you have gone for the immunity hearing? And my concern with this would be that you now have your client testifying, and that testimony is going to get before the jury one way or the other, I would think.
Yeah, I certainly would not have. In fact, Andrew has said that you should go and take a shot, and stuff. I disagree on that aspect alone. I wouldn't have taken a shot on this because it seems, based on what I've read, and I agree with Andrew in this aspect, and the judge, it seems to be woefully short of self-defense. So they mentioned that he suffered from PTSD. You've got to explore that and go all the way with that. And there may be, hurdles, high hurdles in that in bringing forth an insanity defense or a mental incapacity defense. But it's, when you try two different defenses and see which one sticks, the jury, you lose all credibility with the jury. Go with one and you hit that and you hammer that. And I think particularly in this case where one defense, self-defense, doesn't even appear to be remotely close to being reasonable.
Right. Andrew, I mean, to your point, the judge really, you are correct, that the judge was so strong about this is really not stand your ground defense. Do you think it makes sense to still pursue a self-defense claim at trial, or do you think, to Vinu's point, maybe they should just go into some sort of a mental defect defense?
Well, certainly mental defect defense would be an option. I don't claim any expertise in that area of the law. My area of expertise is simply the use of force stuff. But this falls so far short of anything that could be justifiable use of force. I think some kind of mental defect. That's surprising because
it's Florida, right?
Would have to be considered. Now, I also certainly agree that although technically you may be able to argue those inconsistent defenses in front of a jury, they never accept that. They need to hear one story. You can make that argument in front of a judge at a pretrial hearing, or if you were having a bench trial, because technically he can better understand those fine areas of the law. But if you present two inconsistent defenses to a jury, they simply don't believe either one of them. Right.
They just sort of cross themselves out. Now, is there any way to improve the self-defense argument in front of the jury, now that you've seen how woefully inadequate it was in front of the judge, Andrew? Or are they just stuck with these facts, stuck with this testimony, and really grasping at straws if they decide to go for the self-defense defense?
The latter.
Yeah, it's
I mean, this evidence is going to be in front of the jury. It's horrible evidence for any kind of self-defense claim. It doesn't even, as we said, it doesn't even approach being self-defense. Every single element of a self-defense claim here is profoundly defective and vulnerable to prosecutorial attack, and the prosecution only needs to disprove any one of them beyond a reasonable doubt for self-defense to collapse. It's likely he could disprove every one of them.
Well, let's go through the other four. I'm going to forget them now. Innocence, we've gone through. The other second was imminence.
The second is imminent. So the threat you're defending yourself against must be an imminent threat, something about to happen to you right now. Now, during the self-defense immunity hearing, the defense attorney did suggest an argument saying essentially, well, it doesn't have to be something that's about to happen in the next instant. It could be something that's hanging over your head, that's in essence otherwise unavoidable. And I've seen that argument successfully made in the past, but that threat that's hanging over your head still can't be a speculative threat or an imaginary threat. It still has to be something concrete. A hypothetical example would someone straps a bomb to you and the bomb is ticking off. It's not going to go off for 3 hours. So it's not an imminent threat in the sense that it's going to happen the next instant. But it's otherwise unavoidable if you don't do something about it, and it's specific and concrete. The argument Woodward's attorney was making here is that this bad relationship, this acrimonious relationship with the neighbors and their kind of ambiguous verbalized threats would meet that standard, and that's simply not the case. You certainly can't use deadly force in particular against some kind of speculative future threat.
And what about the third prong? I want to go through all 5 before we let you go.
Sure. The third is proportionality. It has to do with the intensity, the degree of force you use in self-defense. That needs to be proportional to the threat you're facing. And also the duration of the force, how long you continue to use force. And something people need to keep in mind, because we all hear about using deadly force in self-defense, but what the law really allows for, it doesn't provide you with a license to kill people. It allows you with a license to use deadly force, to neutralize a threat.
Right.
If the person you use that force again happens to die or not die, that's rather inconsequential to the legal defense. What really matters is whether or not the conditions to justify deadly force were permitted. But if your use of deadly force manages to neutralize the threat without killing it, you're not allowed to go on and kill that person just because.
Right.
And in this particular case, he fired many rounds into each of these individuals, 31 rounds in all, emptied 2 magazines from his handgun. There's no circumstance in which, even if they'd been armed with guns, which there's no evidence to suggest, that could have been a reasonable and proportional use of defensive force.
Wow, it sounds like he's got a really uphill climb to make when even the most stellar expert on the law of self-defense that I've ever come across cannot find anything for him to hang his hat on. I think we've got a real problem, don't you think?
I just call them as I see them, and this is clearly simply not a case of self-defense.
All right, ladies and gentlemen, Andrew Branca is honestly the person to follow. And if you need to know about the law of self-defense, check out his website, check out his books, check out his classes, follow him. Are you still tweeting, Andrew? I haven't seen anything from you recently. Are you still following cases and tweeting?
I've greatly reduced my my tweeting volume because real work demands my attention. But if there's another big case that's actually self-defense and is worth covering from my perspective, then I imagine I'll jump back on.
All right, so trial watchers, make sure that you're watching Andrew, because if there's a case that involves self-defense, he is all over it. Andrew, thank you so much for being with us, and I'm sure that we'll have you back again soon.